Thank you, Adam, and good afternoon. Thank you for spending your lunchtime with Adam and myself. I'd like to wish everybody happy St. Patrick's Day. That's tomorrow. And of course, March 19, happy St. Joseph's Day. We're going to cover the basics of the workers' comp system today. Those of you who posed us some questions when you registered, thank you, because sometimes I do need to do a little research before we come online to answer questions. And I am going to try to answer the questions that you posed on the slides where the topic has naturally arisen. That's a little bit of learning theory for everyone. So let's begin now with before there's an incident, before there's ever an accident, how to create a safer workplace so that we can avoid an injury or an illness at all. One of the best ways to do this is to form a labor management safety committee in the workplace itself. Up on the slide, we have some suggestions. For example, you can make a committee with an equal number of workers and managers and have them meet with a predictable schedule, and you show up with an agenda, rotate the chair of that committee, and then perform some safety inspections. Talk about the places in the workplace where you're having either incidents or you can reasonably foresee an incident, something unsafe. Also, you might want to review the equipment that's being used, make sure that it is well maintained, it's not been modified, it's not fractured in any way, and also review the procedures that you use to perform your tasks. You want to make sure that everyone has been trained in the safest procedure to do their daily tasks. Do you even have written procedures? Well, this is the place where you can discuss those things to try and create a safer workplace. Workers' compensation is a no-fault insurance system. And when we say no fault, we really mean no fault, as in who's responsible, who goofed up. That's not part of the system. The employers must provide the insurance coverage that pays the benefits for the workers in the event of an on-the-job injury or illness. We've always talked about illnesses, but in the present day, in the midst of a pandemic, illness takes on a special importance. The employees do not contribute to the cost of this insurance, so that means there won't be a deduction on a pay stub saying that, this much money was allocated to workers' comp insurance. This is a worker's right. It cannot be signed away. It cannot be negotiated away. It could, in fact, be enhanced if the labor and management at the workplace agrees to enhance the benefit. That's all right. And that does happen, particularly in collective bargaining agreements. We had a question ahead of time. Someone said, what's a qualifying injury for workers' comp? Well, this is a good place to address it because workers' compensation injuries or illnesses are things that require more than 2 treatments of first aid. That's the legal threshold. So if you're seeing a doctor for an injury or another healthcare provider for an injury and it's not first aid, you have a workers' compensation claim. Also important to point out is that immigration status of the worker is not a factor in workers' compensation. It's not a factor. It's really that categorical and that simple. So we don't ever have to worry about questions of visas and how one arrived in the country. That's not a factor. Finally, language assistance services are available to injured workers from the Workers' Comp Board. On the one hand, when it comes to written materials, we have our publications available right now, free for download, free for distribution, in the languages that more than 90% of New Yorkers speak. That's on our website under publications. Also, If a worker is having a hearing and needs a translator because the worker speaks a language other than English, we will provide the translator at no cost. Also, if you call my office, which we'll talk about in a moment, well, I have a Spanish-speaking employee who will speak to you directly in Spanish, because Spanish accounts for about 76% of the translations that we perform here at the board. Here's a little bit about the board, Adam's employer and my employer. We administer and we oversee the workers' comp system. We do not pay the claims unless, and I'll talk about the unless in a moment, and that's a very small number of claims where we have to pay. We're the regulator of the system. We have offices all across the great state of New York, and the way we accomplish our function is we receive reports of all injuries and all payments. We also receive the medical records related to a claim. And one of our primary functions is to hold a hearing when appropriate to adjudicate a claim or to move it forward. There is a hearing component to this system. We have law judges who perform those hearings. This is me now, the advocate for injured workers. I'm actually an ombudsman. That means I'm concerned about the health of the system, but I'm also the head of an office where we help injured workers access their benefits. So we tend to come into play, or we tend to be reached in very difficult claims or, very complex claims. There's also the matter of the fatality claim, because we will discuss the fatality benefit, and we are involved in the start of those claims because we will work with the surviving family to help them access that benefit. I do an awful lot of work with the 9/11 community because if you don't know it, that situation is ongoing. I have not spent a week at this board since 2008 when I have not spoken to a World Trade Center responder. Who pays your claim? This is a key topic. Okay, this is a fundamental aspect of the system. This is a no-fault insurance system. That means there is an insurance policy somewhere that is paying the benefits. If the employer purchased a policy directly from an insurance carrier, okay, there are about 260 carriers who are licensed to write policies in New York State. The largest one is actually called the New York State Insurance Fund. So their name is similar to ours, but the New York State Insurance Fund is in no way connected with this agency. They are a wholly separate entity who writes workers' comp insurance and disability and paid family leave insurance. And so they, like the other 259 carriers, they're actually paying. But there is another way to insure, and it is called self-insurance. We had a question earlier, during the sign-ups about self-insurance. And self-insureds are operating under all the same rules as an insurance carrier is. So this is an instance where an employer can be self-insured, which means they're paying the claims out of their own funds. Now, who does this? Well, on the one hand, public employers, municipalities, school districts, cities, states, counties. In New York State, they can self-insure, and they very, very frequently do. Also, private entities can self-insure, but that's a whole different thing because if you're a private corporation and you want to self-insure, you have to demonstrate to the board that you have the funds available to pay these claims. And, there are deposits that have to be posted to ensure your viability. It's a process these employers will work with the board. We have a very good process in place there to ensure the viability of those payers. There are about 120 corporations in New York that self-insure. These are the very, very, very largest corporations, the multi-billion-dollar corporations. Some of them choose this. But either way, if you're self-insured, you are almost certainly, it's not set in stone, you don't have to, but they almost always hire a claim administrator to actually handle the claim. The technical term for that administrator is a third-party administrator, and those third-party administrators, known as TPAs in our system, because we love acronyms in this system, but I don't, so I don't use them. But these administrators are licensed by the board, by our employer, to operate. So sometimes I will receive complaints about behavior and so forth, and that's fine. That's my role to field those. But the point I'm trying to make here is that if you are an injured worker or you're an advocate for injured workers, please remember, once there's a claim, the employer is pretty much out of the equation. The worker will be dealing with either an insurance company or a claim administrator regarding the events in the claim. And it's an important little distinction that really helps workers when they understand this. Now, on the slide is the last bullet that says the board will advance payments when no insurance is in place. That's that instance I was discussing where the board will actually make the payments, but it's only in that instance where there's no insurance at all in place. The employer has failed in its responsibilities to provide workers' comp insurance for its workers. Those instances are subject to great penalties, and by great I mean large. And also, what happens is the board treats it like any other claim, and then when the decision is made regarding benefits, the board advances the payments, and then the board bills the employer personally. So the lesson here for workers is, don't worry about who the insurance company is, just file the claim. Okay. Oh, on that topic, if you ever need a carrier case number, if you ever need the case number that the insurance company has assigned, well, just call us. We'll give it to you. We will give you that carrier case number. We have it in records. Okay. Who needs coverage? What is the requirement for business to have workers' comp insurance? Okay, it does not go by size of the business. It goes by number of employees, as in, do you have one employee? You need coverage. It's really that simple. Do you have one part-time employee? You need coverage. If there's an employee, you need coverage. That's for businesses, and a business is for-profit in this jargon. So most nonprofits with employees are also required to have coverage. Okay, so I mentioned the employee threshold. Who's an employee? Well, on the for-profit side, anyone who's providing services to a business can be determined to be an employee. On the nonprofit side, any compensated individual can also be determined to be an employee. The exception there is very, very limited. It has to do with people such as clergy or teachers in a 501c3. So here's a general rule. If you have people working for you, they could very well be considered employees for workers' comp purposes. You should probably consider getting insurance. If you are very interested in this topic, I'm going to recommend you do the webinar that the Advocate for Business offers once a month. Adam would be your host for that one as well. You can get that schedule on our website. But I do have one more thing I want to say here. I would like to speak for a moment about independent contractors, because that's a term that's very much in public use today. There are a number of employers who might say, I don't need workers' comp. I have independent contractors. Everybody's an independent contractor. Well, here's a general guideline about independent contractors. The standard we use boils down to direction and control. Is the employer exercising direction and control over the activities of a worker? If yes, then that worker could very well be considered an employee for workers' comp purposes. Please bear in mind that there are a number of governmental agencies who do have a consideration for independent contractors. Labor Department, Tax Department, Workers' Comp Board, we're all interested in independent contractors, and we all use our own definition because we're all operating under our own set of laws. We here are under the Workers' Comp law, which is very different from the tax law. So it is possible for one to be an independent contractor for workers' comp purposes and not for tax purposes, or more likely, it's more likely that a worker is an independent contractor for tax purposes, but not for workers' comp purposes. This is possible, and it does happen, by the way. All right, that's the background. Now let's talk about what to do if there's an injury. First, workers, get medical care right away. Take care of yourself. Your mother was right. Get the medical care. Employers, please get the worker to medical care. Please don't get in the way of the worker getting medical care. You could see any provider in an emergency, but if it's not an emergency, then you should be seeing authorized providers. Okay, so now you've gotten the medical care. Good. You're stable. You're able to do task number 2, which is tell your employer in writing that you had an incident. Yes, you have incident reports at work. That's great. You need to tell the employer in writing about this incident because that's what we call notice. So how do you do it? Well, you can certainly send an email. You could do the incident report. You can file a document. We don't recommend that you use a text message. And even though it's acceptable, I just need to make the point in 2022 that we don't recommend you use a text message because they're very difficult to find and reproduce if you ever need to. I think we all know that. Okay, the next step, file the employee claim. It's called Form C3. That is a form you get from the board, and you're filing it with the board. Okay, that's all you have to do is file it with the board. You can do it online. Come to our website and do it online, please, because it's the fastest and it's the easiest, and frankly, it is the most legible. If you feel like you need to do it in writing on paper, that's okay. You're going to have to print it, and then you'll fill it out by hand. And then finally, you should be continuing to get any necessary medical treatment. The whole thing about the employee claim, Form C3, just want to make a point here that it is mandatory that your employer tell its insurance carrier, and it is mandatory that the carrier tell the board about the incident. However, this other step is not mandatory, but it's a very good protection. Okay, so now, after all of that, I'm going to turn it over to Adam, who is going to give you a short quiz, if you don't mind.
Thank you, Joe. You'll see on your screen here, we have a scenario with Kadir. Kadir is not an American citizen. He is in the United States on a work visa. He works 40 hours a week on site at a software company, uses a desk that the company, using the company's equipment on tasks that are provided by the company. He works a standard 8-hour day. His start and end times may vary. He works on a 1099, so the software firm does consider him to be an independent contractor. One day, Kadir is inattentive. He drops a computer server and he breaks his left leg. The employer calls an ambulance that takes Kadir to the hospital. In this scenario, do you think Kadir should file a claim? You can enter your answer, yes or no, right in the chat box here. I see we got a couple answers here. We got a couple yeses, a no, a slew of yeses. We have, oh, Joe, we're getting tons of yeses, and what do we think?
Well, we have we have one person who suggested that maybe Kadir's an independent contractor, or it might be too soon to tell. Okay, if I had to make a judgment based on this fact set that, frankly, I wrote, yes, of course Kadir should file a claim, and there is well, let me talk about that for a moment. Yes, Kadir absolutely should file a claim because there is no penalty for filing a claim. Okay, if you think maybe workers' comp pertains to you, file the claim. Just be truthful. Just give us the facts. There's no penalty if the claim is never established. Now, would Kadir get paid? Well, based on this fact pattern, I'm not a judge, but there's a pretty good likelihood that he very well may, because we threw in a bunch of red herrings in here for you about he's not an American citizen. Doesn't matter. He's in the U.S. on a visa. Doesn't matter. Okay, he's working on site, using the company's equipment. They're assigning him tasks. Well, it's a potential argument that they're exercising direction and control. They pay him on a 1099. Okay, so that's a tax situation. That's not necessarily determinative in our system. And, he's inattentive, and he dropped the server on his leg and broke it. He's inattentive. Well, that would be fault, but we're a no-fault system. Okay, and the employer called an ambulance. Well, the employer could be construed to have notice of the incident just by virtue of calling that ambulance. So this is fictitious, and I didn't just decide the claim, but I just explained to you a number of issues in that situation. Okay, now let's talk about the benefits of workers' comp. There are 3 primary benefits. There's the medical care, there's the lost wages, and then there's the fatality benefit. Let's start with your health, the medical benefits. There's no cost to you for medically necessary treatment for your work-related injury or illness. This is a lifetime benefit. That means that so long as you don't settle and permanently close your claim, you are going to have lifetime medical care for your established injury or illness. This is hugely important. This is especially important in an environment where we are in a pandemic, where we don't know what's going to happen to all of our health in the future. If you are an insurance carrier, you're a TPA, if you're a professional on that end of the business, please, I'm asking you nicely, do not tell injured workers that their claims are closed when they're not. There's a reason I'm actually making this request is because about once or twice a month, we're contacted by a worker who has an old claim who said that he or she spoke to an adjuster who told him or her that the claim was closed because it was from 1989. Well, unless there's a settlement, the claim's not closed. I understand you have reserving. I understand you have internal procedures where you might consider a claim closed, but please don't say that to a worker because then the worker thinks the worker cannot see a doctor because he or she's having an exacerbation. All the medical expenses are payable, laboratory, hospitalization, surgery, PT, physical therapy, DME, durable medical equipment, home care. Transportation. Well, before we talk about transportation, let me answer a question that came in. Someone had a question about medical treatment guidelines. Yes, there are medical treatment guidelines in our system. They call for certain practices and certain procedures and so forth in the care of injured workers. If you're a healthcare provider, you will understand them. If medical treatment guidelines are a topic for you that is of professional interest, it's a very big topic that requires a certain level of specialization to even convey to you. Please take one of our webinars. We have webinars generally through the medical director's office where we do address topics of interest to healthcare providers. So the best answer I have for you on that is go to the website, go to the webinar page, just type webinar in the search bar, and you'll come right to the page. You'll see all our webinars, and we probably have one for you on that topic. The last thing I would like to mention, though, is transportation costs. They are reimbursable to injured workers for medical care. So you can file Form C-257 and get your transportation costs reimbursed to and from your medical care. We just had a question pop in. The question is asking, are all medical expenses payable as long as they go to a provider that participates with the workers' comp system? Well, yeah, the expenses for medical care from an authorized provider in an established claim for treatment of established injuries, yes, potentially they're going to be payable. The variable here, though, is it kind of goes back to medical treatment guidelines now, and it goes back to authorization requests. Did the service conform to the medical treatment guidelines? If it did, then yeah, we would expect it would be payable. If it didn't conform to the guidelines, well, then we have to really look at it and see what happened. Was a variance requested, and so forth. So generally speaking, the answer is yes. Generally speaking, but there could be a small exception out there. I would have to spend way too much time on this to get to that point. Here's a best practice for medical care. In cases of ongoing disability, that means you're getting a workers' comp payment. You're temporarily totally disabled, let's say. This is when it would happen. The worker has to see the doctor or healthcare provider every 90 days because that doctor has to give an opinion on the level of the worker's disability. It's called a degree of disability. Item number 2 on that slide. Degree of disability will range from 0% to 100%. It's usually expressed as a number. 0%, you're healthy. Yay! 100% disability? Well, this is a provider saying, I don't think you can work. You're 100% temporarily disabled, and that would entitle you to the full comp benefit that mathematically works out for you. So understand that, and if you're getting payments, see the doctor every 90 days. If you're a provider and it's a comp case and your patient is temporarily totally disabled, schedule, please, within that 90 days, because if you get to day 91 and there's no degree of disability, the insurance company is within its rights to stop paying you, and they exercise that right. Finally, here's a little helpful tip from Joe. When you go to the doctor, please arrive with the essential information. Your WCB case number, that's the number we assign. It'll be 8 characters, probably starts with a G. The insurer's case number, that's known as the carrier case number. That's the insurance company's number. Please bring that, and also bring the insurance company's name, the claim administrator or the insurance carrier, because that's who's going to actually pay our doctor for these services. You're just helping everything go a lot quicker in that instance. I had a question beforehand about something called medical maximum improvement, MMI. Well, I'm going to address it right here because this is where we're talking about medical care. There is a concept in the system called medical maximum improvement. That means you are as well as you're ever going to get. That is something that has to be decided by a healthcare provider. That is used in the process because at that point, the worker might either pursue a schedule loss of use benefit or permanent total disability, permanent partial disability, total industrial disability. These are all benefit areas that require a judgment of maximum medical improvement, and it's going to be some period of time after the initial injury. Could be 18 months, could be 2 years, could be 4 years, depending on how grievously the worker was injured. Let's talk for a moment about independent medical exams. This is when the insurance payer is asking the worker to to attend an exam given by a physician that it has hired for an opinion on the worker's health. The doctor who's hired will have specific questions to answer. Here's what workers need to know. Number one, there's no doctor-patient relationship here. You don't have to treat that doctor who's examining you the way you treat your personal physician because there's no doctor-patient relationship here. That physician is not going to answer questions, is not going to talk about your treatment and give you treatment options. He's just giving an opinion on your disability as a consultant. However, you may bring a witness to that exam. Go on ahead. Someone, maybe the witness, may record the exam, video and audio. Cell phone camera, go on ahead. When the exam's over, the worker and your attorney, if you have one, and the insurance company, they're all going to get a copy of the report. Review that report. Make sure everything that is stated in that report was performed and that the judgments that were made based on tests, seem to make sense. You may claim, this is why, by the way, the video is so helpful to you. You may claim travel reimbursement to and from these exams the same way you can from medical care. You may claim that reimbursement. It's probably going to be an easy reimbursement for you to get because there's going to be a record of the exam in the file. The biggest problem that workers have when they try to get reimbursement for trips to medical care is that the medical bill and report has never been filed. That does happen. So if that's the case, the carrier's not going to pay because there's no evidence that you actually went to this exam. Also, last element on independent medical exams, complaints about IME conduct should be made to me at the Office of the Advocate for Injured Workers. Contact information to come. I will receive them, review them, and then I will take them to the IME Review Committee because we do have a committee that reviews these. Now, we're talking about conduct. Was your exam performed in a medical facility? Was everything above board? Did you make a video that does not show 4 tests on it that are suddenly in that report? Okay, these are examples of conduct. If you think you're 100% disabled and the insurance doctor says you're 50% disabled, that's not conduct, that's not fraud. That is a difference of opinion that's going to have to be litigated. But conduct complaints, please direct them to me. We do take them very seriously. A very large IME company was removed from the system about 13 months ago based on these complaints. When filling out a C-257, Adam, is it helpful for the patient to submit with a copy of the note for the appointment they traveled for? No, that's not necessary. The key thing is, number one, did you get your mileage correct? Number two, is the doctor's medical report in the file demonstrating that an appointment did happen? That's the standard. Okay, shifting over to cash benefits, the second primary benefit. The lost wage benefit works like this. Let's say a worker cannot work due to injury. The benefit is going to be 2/3 of the worker's average weekly wage. Okay, so we're going to take the worker's wages from all jobs. If you have 2 jobs, you need to tell us about both jobs, because if you can't work one, you can't work the other. So all your compensation counts, and then if you're 100% disabled, you get 2/3 of that. But the good part about the 2/3 is that it's tax-free. Okay, we had a question on that. Workers' comp benefits are tax-free. The maximum benefit right now is on screen, 1063.05. So that would be based on a payroll of about $1,500 a week and change. So if you're earning $1,600 a week, this would be your maximum benefit. All benefits are temporary unless the injury becomes permanent. I was talking about that before with the maximum medical improvement. So if you are grievously injured and you start to see documents that say you're temporarily totally disabled, well, you're not going to be permanent unless you are permanent, and you're going to have to get to maximum medical improvement for that decision to be made. There are also payments for loss of the use of a limb. That's called schedule loss of use. The law does have a chart and table with each body part that counts as a limb. So that means arms and hands and fingers and legs and feet and toes. And the law does specify a number of weeks for the complete loss of the use of a particular limb. If you should injure your arm very terribly and you get as well as you're ever going to get, and the doctor says, well, you have lost 10% of the use of that arm, we go on the number of weeks that are payable for the total loss, and you'd get 10% of those as the benefit. Also, we had the question about taxes. Well, they're tax-free. Pension. What's the impact of workers' comp on a pension? Well, this goes to service credit. And it is distinctly possible that if you're on workers' compensation 100%, you are not going to be accumulating service credit towards your pension. Okay, that is distinctly possible. You need to check your contract on that one. Also, the last item on here, this is a tip from Joe to you. Please remember this for the rest of your natural life. If you are paid in cash for your work, get yourself a notebook. Make yourself an electronic record, however you're comfortable, and record what you were paid, how much, by whom, for what service, on what date. This is going to be very helpful information in a number of different forms, but particularly in workers' compensation, where we're going to need to know your average weekly wage, which means we're going to need to know what you earned for the 52 weeks before you got hurt. So if you have this written record, that's a whole lot better than saying, well, I think this and I seem to remember that. It is with great joy that I tell you that as of last July 1st, 2021, insurance payers must offer direct deposit. If you are an injured worker, I am urging you to sign up for this. If you're a payer, I'm urging you to publicize this with your beneficiaries. This solves all the problems of lost and missing and delayed checks. Finally, the third primary benefit is the fatality benefit. If a worker is killed on the job, or if employment is the cause of a worker's death, there is a fatality benefit, and this is where my office comes in directly because we help the families claim this benefit. Funeral expenses, up to $12,500 is reimbursable in the New York metro area. That's New York City, Long Island, Westchester, and Rockland. It's $10,500 in the other New York State counties. There's a weekly payment that is calculated in the same manner as the lost wage benefit, and it's payable to surviving family. We're talking about spouse, children up to 18 or up to age 23 if they're attending higher ed in an accredited way, and also disabled and blind dependents. Those particular people with those particular relationships, they are the surviving family for workers' comp purposes. If they do not exist, $50,000 is payable to the worker's parents. If the parents and those other parties do not exist, $50,000 is payable to the estate. If you are related to a worker who passed away due to employment and you're not one of those parties, you have to deal with the estate. We will not and cannot award you the benefit. Finally, I do want to take a moment to tell you about Kids Chance, which is a nonprofit. It's a national 501c3, chapters in every state, and this organization provides scholarships to the children of workers who were killed on the job or who were grievously injured. I happen to know that they're looking for scholarship applications, and it's March. College students are probably thinking about what they're doing in the fall. So if you're interested in this, why don't you please visit the website that's on screen, kcnewyork.org. Now let's talk for a moment about COVID-19. COVID-19 is an infectious disease. Infectious diseases are payable in the workers' comp system in New York. Can't speak for every other state, but in this state, yes. So, what does that mean? If you think you contracted COVID due to your employment, you should be filing a claim. Today's March 16. We have had COVID in New York for 2 years now. There is a 2-year window of time to file a claim after an incident. So if this is you, get that claim in now. Don't preclude yourself, okay? If you're not sure about whether it's 2 years, whether it's, it's 1 year and 364 days or 2 years on the dot, just send the claim in. Let us sort it out, okay? What are you going to file? Well, this is like every other workers' comp claim now. You're going to need medical documentation. There's probably a positive PCR test out there. Send that in. If you saw a doctor, send in those reports. If you haven't, but you want the doctor, you might have to go to a doctor to get an opinion on the likelihood you got it at work, because this is the standard we are using. Prevalence. Is it likely you got it at work? Was COVID prevalent in your workplace? That's the standard we're using because we realize no one can pinpoint a moment in time when they got infected. So, you see on screen, the bullets. These are the things you should be discussing with your provider when you get that opinion on likelihood. Did you have public contact? Did people wear masks? Did you wear masks? Did the public? Did your coworkers? Was COVID-19 prevalent? Do you know that the public had COVID? Do you know your coworkers had COVID? Were you a healthcare professional who's working in a COVID environment? These are things that you should tell the provider. And the provider will also ask questions too, because this is a public health crisis. They have a protocol as well. There's a fact sheet, a short video. There's also an entirely new COVID page on our website with a huge amount of material. I recommend you visit that. Now, Adam would like a word with you.
Thank you, Joe. All right, we have another scenario on our screen. As you can see, again, just like last time, you can enter yes or no in the chat box. So we have Liz, who works at the front desk of a cardiology practice. She checks in patients, handles copays. One day she feels ill and calls into work. The cardiologist recommends she get a COVID test. Turns out it's positive. Liz receives paid sick leave for the 2 weeks of work that she misses before testing negative for COVID and returning to work. During the time, Liz has been vigilant about following all protocols for COVID. She has worn her mask, she has socially distanced, and she knows the office has treated patients with COVID in the past, and the doctor recently at the practice also tested positive for COVID. So knowing all this, do you think Liz should file a COVID claim? Again, right in your chat box. All right, we're getting some answers in now. Joe, we got a no, yes, 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 of course, yes. We got a smattering of yeses and a few no's. So what do we think here?
Well, we think in terms of filing a claim, we certainly think Liz should file a claim, and I would be interested to know why you think that she shouldn't file a claim. And she's also working in a healthcare practice where there is COVID right there. So I'm not making a determination that she's going to get a benefit. I can't do that, but I would certainly be interested in how this claim resolved. Yes, Liz should absolutely be filing that claim. There are penalties for late payment. Okay, we're moving into the final portion of the discussion, and then we'll do questions. Benefits have to begin flowing within 18 days of incident or 10 days from when the carrier had notice, whichever is later. Okay, this does happen about 90% of the claims, so that's very good news. If a judge makes a decision, there's going to be a filing date on that decision. Let's say the hearing was on March 1st. It'll probably be filed on March 3rd, for example. It's usually 2 to 3 days later. That's in the lower right-hand corner of the decision. So 10 days from that filing date, March 3rd or March 13th, the benefits should be going out to the worker, or penalties are due and payable. Also, it's possible to appeal a decision, and if that should happen, and if let's say the claimant prevails and a benefit is payable to that claimant or injured worker, well, then interest could be due to that injured worker. You do have some responsibilities in this system as an injured worker. You should try to come back to work as soon as you are physically capable or mentally capable, if that's the situation. You'll get that from your doctor. The employer might have transitional duty or light duty available for you if you're less than 100%, but you could still do many tasks. What you do is you ask your doctor for a list of restrictions, things like don't stand more than an hour, don't lift more than 10 pounds. Those are typical restrictions. And an enlightened employer will accommodate you and bring you back because it's to the employer's benefit to get an experienced worker back, but it also removes you from workers' comp, which helps their premium experience. Enlightened employers understand this. Also, please, if you move, tell the board, tell the parties. This is a common but avoidable problem. Understand any agreements that you make. Oh boy, yes, stay involved with your claim. Don't let events happen around you. Understand, ask questions. It's okay. You can ask questions to the board. You can contact my office or the general number. Yes, that's why we're here. If you have an attorney, ask your attorney questions. Now, what to expect if there's a hearing, because almost half of the claims in the system will get a hearing at some point. The insurance company is definitely going to have an attorney representing it. You can hire an attorney for yourself. That's fine. There's going to be a judge there. We don't follow the formal rules of evidence and procedure that courts use. It's not like law and order. As a matter of fact, we are not a court at all. We're a little different. We're a little less formal, I ought to say, but everything still does operate with decorum, and we are still interested in facts. Witnesses might be called. Depositions might be taken. The judge is going to make a decision based on the findings of fact. Decision will be filed, as I explained. So the big thing here to take away is that due to the pandemic, we are not holding these hearings in person. Our offices are closed to the public, so we are having what we call virtual hearings, which means the parties are connected either by the virtual hearing app, which is essentially a teleconference app, or by phone. So you can download the virtual hearings app. It's available in the Apple Store and the Google Play Store. Or you can access the virtual hearing through a computer, through a tablet. I think you can use a cell phone, but it's, on a cell phone, the screen would be very, very small, but you can. And this is how you would attend your hearing. If you want to attend via the virtual hearing or by telephone, you're going to get a hearing notice. The directions will be on the hearing notice. Okay, everything will be on that hearing notice. If you want to attend by telephone, that's fine. Just please remember, the judge is going to call you. You're not calling in. Your lawyer's not calling you. The judge will call you. So that means you need to get in touch with us before the hearing occurs to tell us what number the judge should use to call you. Stay involved in your claim, please. Here's our website, wcb.ny.gov. Sign up for eCase. eCase allows you access to your claim, and you can see all the documents in your claim. Your employer is probably not going to have the most current or correct information about workers' comp. It happens because that's not your employer's business. If you have questions, contact us. We will answer them for you. Finally, we're very proud of this. We are creating a new software system to handle workers' comp in New York. The first phase has to do with health care. It's for insurance carriers and providers. And we launched the first items on March 7, and it's working very nicely. We are going to be rolling out additional components. There's another component that's due early in April. There's another one due in early May. And we're on schedule. So this is just us letting you know that this is happening. It is going to make a positive difference. If you want more information about this, we have webinars like crazy on this. I think there's even one happening right now, frankly. But we do have many, many, many webinars on onboard directed to different audiences. Go to wcb.ny.gov/onboard or go to the webinar page and you can get the schedule. Here's our social media presence. We're on a number of channels. The last item says notify. You might have already done that. You can get notifications about the system if you sign up there. Just calling out the YouTube channel because we have at least 100 videos at this point available on our channel, and many of them are training videos, including recordings such as this, because this recording will live on our YouTube channel within a few days. Now, it's question time, so I'm going to leave the contact info up on screen for my office, and I'm going to turn it back over to Adam, and we'll consider your questions.